Talks.
Hello, this is PJ Smith. Welcome to our podcast on bylaw revisions. I would like you to welcome two guests today. They're both on the board of directors. Marcie, please introduce yourself.
Hi, I'm Marcie Roggow. Nice to be with you today. I am sitting on the board of directors and I'm also an instructor at NABOR.
And co-chair of bylaw revisions for 2024.
And co-chair of the bylaw revisions.
She wants to erase that already. She wants it to go away, but Shaun.
Yes, hi, I'm Shaun Garry. I'm also on the board of directors for 2024, co-chair of the Bylaws task force, and excited to be here and talk about the bylaws. This has been a big undertaking and excited that it's finally in the membership's hands for voting.
Excellent. So let's talk first off, why even have bylaws? What's the purpose of a bylaw? Just in your own words, your thoughts. I mean, to me, it's the foundation of governance for us as board of directors and for our membership. Kind of gives us the guideposts of how we actually do business. So would you like to elaborate, either one of you?
Go ahead, John.
Sure. I think that's really accurate, PJ. It's the sort of guidepost. It's the foundation of our association. It's the legal framework that we operate in. How do we call votes? How do we select our officers? How do we do our business? I mean, this is a not-for-profit corporation that is required to have bylaws under the law. And so that's what they're there for. They are the foundation of our association from a legal perspective. And then from there, we build up your policies and procedures and other pieces with respect to it.
Excellent.
And the bylaws are there for us. When somebody says, well, can you do that? Then you go to the bylaws to see, can you do that? And
gives
so
authority. Mm-hmm.
It's authority to do things. And it's really important that they're current.
So
yeah, for example, I mean, a good example is, let's say you want to attend a meeting remotely and you want to vote on it, right? I mean, that was not a thing when these bylaws were first created 75 years ago. But over the course of technology and time, we need to adopt. And so we have provisions in our bylaws now, and then we've clarified a couple of them that you can attend a meeting and vote depending on the circumstances and the type of matter it is. So that's a good example of where bylaws started 75 years ago and where they are today is very different. So,
not to mention that they did not have. We could connect with you all by email.
Telegram though, and telefax.
You could do telegram and telefax, but not by email. So lots of little things had to be changed.
So in effect, you just answered my question, but I'll throw it out there anyways, but you just answered it. Why change them? Why even evaluate them? How often is this one here? You can answer what's good practices of how often you look at your bylaws and reevaluate whether they need updating.
The experts that we've talked to have said you should be updating looking at your bylaws every 2 years to see if something needs to be updated. The majority of the NABOR's bylaws had not been touched since 1997. The majority of them. There were 3 or 4 times, in the teens, where some of it was changed. But for the most part, nobody had ever thought about looking at them. And it wasn't until we started asking questions that all of a sudden people said, well, that's what it says in the bylaws. We go, but that's not right. That's not how you were operating didn't match what the bylaws said. And that's how we knew it was time to change.
So I just had to do quick math on my phone because I don't know. So that's 27 years. That's a long time.
Long time.
So, all right, let's get into the 3 votes. We have 3 votes that we're asking membership to be part of, which we're very excited about. Maybe you want to do a little historical review quickly on how did we get to this point for these 3 votes first?
John, you want to do the cleanup?
Sure. I mean, historically, I don't know if you mean to go back to how did this process work, or if you want to just get into the bylaws pieces themselves. I can do either. So, well,
December and during installation, I may have announced the most important thing that we're going to do is change bylaws. So, and I already had my task force ready, and I maybe named you two as the co-chairs for the task force. So, starting there, December, we went full blast, and you guys have been working unbelievably so with the task force. So start there.
Yeah. I mean, it is a huge undertaking to amend bylaws. I mean, I think our bylaws are 38 pages or thereabouts, and they're a fairly complex set of legal and other, just complex set of a legal document that you have to look and understand before you can really make those changes to it. And so part of it was, do we understand what our current bylaws are? What are our current practices? And do our bylaws sort of go along with our current practices? And so we had a task force, and Marcie and I, along with other members on that task force, would sit for 2 hours, 3 hours, meet with each other, go over them, talk about the updates that needed to be made. We met with some outside consultants and some other people with respect to it for their good suggestions. And then from there, it was to present those initial findings to the board of directors for their review and their initial thoughts on these pieces. And then from there, once again, it's more work, because just because you have an idea in your head and you think, oh, this is how it should be, doesn't mean A, that you can write it out in a way that everybody can understand and agree with, and B, that you can get a bunch of people to agree with it, that it is a good idea. And there may be downsides to it when you actually write it out. So it was a really, I mean, a 6-month process of working through these changes and having many sets of eyes on them, whether that's legal counsel, whether that's membership, whether that's board of directors, whether that's Carl and Marty and professional responsibility and all those people putting their eyes on each one of these pieces and giving their recommendations and thoughts with respect to it. So I know that's a bit of a long-winded answer, but I mean, that is the process that we have been through, just even on the cleanup. And when I say cleanup, I mean things that typically are not controversial, stuff that just needed to be changed because for compliance or, the telefax or whatever it is we were talking about, those just all needed to be updated. And even that process is still a multi-month process of commentary, review, and discussion. So,
Shaun, you forgot one thing. Past presidents.
Yes. Well, I mean, of course, past presidents. I mean, of course, past presidents in terms of the commentary for membership. And, look, they have an interesting perspective. They've lived through this. They have very strong feelings about a lot of these provisions. And so it's trying to understand their perspective, understand why it may or may not be a good idea, and then trying to come up with a way to make it work. I mean, if you were diametrically opposed on one issue, is there a way to make it more palatable, for example, on that issue that would garner more support? And so that was part of the process. And I'll say on the more substantive changes, that's sort of 2 and 3. Can we do that in a way that, maybe not everybody's 100% happy, but we're more happy than not on a certain provision?
Exactly. And I think we love the diverse opinions and the perspective, and try to find a middle ground that helps with us with our concerns of our fiduciary responsibilities, risk management, changing times. And so I think we're in a good place. And Marcie, you want to chime in, or should we get to 1, 2, and 3?
I'm just going to say the cleanup, the first part of it was just simply doing all the stuff we've just talked about. So even cleanup kind of had some controversy, but that's the first section and everything's fine. And it was just doing the cleanup that needed to be done. So that was the first section. Then vote
number one was housekeeping, cleanup, a few changes that just kind of made it more, I want to say, modern and aligned with how we do business.
Right.
I mean, and just as an example from cleanup, I can give you 2 seconds. We eliminated the lifetime membership, and the reason is that nobody has lifetime membership. We have a Hall of Fame voting now. But just eliminating lifetime membership meant that we had to amend, 5 or 6 different sections that related to it. So just that cleanup of eliminating the lifetime membership, which is not a thing that NABOR does, required a lot of work and coordination with respect to it. So that's just one example of sort of a cleanup that took a little bit more effort than maybe you might think otherwise.
And PJ, we should probably add here, Shaun is our scribe. When you look in on these documents and you see red lines, Shaun's the one who did all that work. So it was a lot.
I'm shocked.
All that work and all that responsibility, right? Yeah.
Wait, and he's still talking to us, or me. I'm just so impressed.
Yeah.
Let's go to vote.
You just have to be careful. We talked about it. I mean, if you've over redlined something just by 2 sentences, it changed the whole meaning. And so, that's the type of thing that we had to work through, even on non-controversial sections.
Absolutely. And having Greg Urbancic available for really interpretation, unintended consequences, and just, language review so that you have another set of eyes that you feel comfortable with was amazing.
Yes.
Okay, next up, we're going to vote 2, which is the changes of the eligibility and disclosure requirements for candidates. Maybe talk about what that changes and how it exists currently before the final vote.
Shaun, you take that one. I'll take 3.
Okay, sure. This was an important one from my perspective. I probably didn't mention I'm also an attorney. I don't represent the association, but I am also an attorney, practicing attorney. And so I think, from my perspective, it's important that we don't currently have any background checks on any individuals that apply to be an officer or director of our corporation. This is a significant nonprofit with significant assets. We don't have any background checks right now. We don't even have any disclosure requirements that if you have any issues that may need to be disclosed, then there's nothing there that requires you to do so. We have the process goes to our nominating committee. So when you apply to be an officer or director, the nominating committee will review those applications and will make recommendations based on those applications and interviews. And at the moment, there was no authorization or ability for any types of disclosures for any type of criminal matters or other civil matters relating to real estate law violations. And so this provision allows, or at least authorizes, that on the application that information would essentially become available to our legal counsel to make sure that you have properly disclosed to the nominating committee any of those issues that are identified. And to be clear, the only pieces that we added for eligibility are the same pieces that are requirements for membership. So to become a member at NABOR, you must not have been convicted of certain types of crimes related to real estate, and you must not have also been have a civil judgment for items related to real estate fraud or other types of real estate malfeasance. And so we essentially just took those requirements for membership and then added them back into for the officers and directors, because we don't actually check. It appears to be, we don't check on a regular basis to see whether or not those initial disclosures when you became a member are still accurate when you are applying to become an officer and director. So to me, this is really important that we have that piece in there, and I'm in favor of that type of a change to our bylaws.
So just focused on real estate related issues and its disclosure. So I say no, I've never had a judgment related to fraud, related to a transaction, and then you do the background check and boom, there it is. Then there's a discussion between the applicant and our legal counsel, who right now is Greg Urbancic. And then you go from there. It's just like, they'll have a conversation. And if that conversation leads to, and I think I'm not gonna, this doesn't work for me. I don't want to disclose this. I don't want anybody to know about this. I'm sorry I messed up. Could be another one. And, you disclose and, then you move on. So I think, our staff has background checks. That's one thing. But, I've heard from the membership that they thought we already did this. So, and we're in a state in the world right now that this is pretty much essential, especially with what's going on with NAR and all these things. You just don't know. And, if you're not in favor of this, I just can't imagine why.
I think it's a pretty basic requirement that there be background checks and disclosures for your officers and directors of a very sophisticated, well-resourced corporation. I think that's appropriate I think it's just appropriate from a fiduciary perspective, frankly, as well. So I think it's a really great change. I hope the membership sees the reasons for it and is willing to move forward with it.
So we are attaching a PDF that kind of goes through what we're doing right now. We're looking at what the proposed changes are and what the current bylaws are. So feel free to download that. It'll be on the link below. Marcie gets vote number 3, which is to change the petition process on the ballot of the Board of Directors election. This is super fun. Marcie?
Well, most people, frankly, don't know that at NABOR, the nominating committee meets with candidates, and then they select those people, 5 or 7 of them, select all the officers and the directors where there's a vacant seat. And they
Oh,
prepare
a slate, right?
That's what I was just going to say. They prepare a slate. That slate is then presented to all of our members at the annual meeting, and everybody votes, yes, that's fine. That annual slate. And we found out so many people went, well, don't we get a say in anything like that? You just have a slate and that's it. That's the way it's done. So in our bylaws, it said, if you had applied to the nominating committee and they did not pick you to appear on the slate, and you had gone through that vetting process, then you could get petition signatures to try to get on the slate, get on the ballot. And so that amount was 10%. So we have roughly 8,500 members. So you would have to go out and get 850 signatures in order to have the petition brought forward to the board, to the secretary, vice president, and then to be on the ballot. That's a lot of signatures. And so as we discussed that, and we had lots and lots of comments on it, some people said, we don't want any signatures. We just say, go for it. And the other people said, no, we like 10%. So we settled at 5. So you have to have either 5% of the total membership signatures on a petition or 500, whichever is more. And that gives people the chance that if they want to try to get on the ballot, that's how they do it. And I think, PJ, what was really important in our listening sessions that we did 2 listening sessions. And we had, I've added them up, somewhere around 7,500 or 75 of our members that came and listened to all of this discussion. And one lady said, I want to have choices. And so I think that we had a great discussion with those members, and they all agreed that that petition number should be lower so that people can apply if they want to.
Well, I would say this is a happy medium. I don't know if anybody agrees on anything anymore, but this was a happy medium, and I think, yeah.
I think, yeah, I think that those listening sessions also demonstrate the fact that we were able to listen to some of the concerns that people had who thought this was too low of an amount, and what the basis for those concerns were, which is that there could be some brokerages that number in the many hundreds of agents that could use that system in a way. So what we did is we added a provision that said that of those, either 5% or 500 signatures, no more than 25% can come from the same brokerage. So that means you couldn't just have one brokerage; you'd have to have multi-brokerages that were supporting a candidate to be added to the slate. So that's an example of where, when we got the feedback from the membership and the listening sessions, this is hopefully a way to address that.
Well, regardless of what the number is or whatever, it's a big undertaking, and it has to be something that is verifiable. It isn't that I just sign a piece of paper, like if you were at a state fair and you sign up to do something. This is something where it's signed and actually, I don't want to say notarized, but it's an actual signature with a date. Yeah, and you have to have your license number, and it's not as easy as it sounds. And I'm hoping that this actually never gets utilized, and that the selection process gets more, with the background checks and the things that we've changed will make this better. We'll see. And you know what, this is, if we have to change it, you'll have to change it. I don't see unintended consequences coming into play, but you just never know. But
yeah, the other thing too, PJ, is just that you can't run to be the treasurer, the incoming president, or the vice president unless you have served for at least 2 years in the last 5 years on the board. So that means that, hey, look, if you don't have any exposure to the way the business of NABOR works, then you probably need to get that experience first before you're going to go run from as a slate as an open candidate. So that is a sort of a restriction that was put on there, once again, to hopefully balance the concerns, but also make it more available. If you want to be on the board, hey, great, you can get yourself added with getting those signatures, and then you can go out there and you can campaign. But so that's just another example of a way to make sure that it's appropriate.
Kind of a safeguard where we're trying to do a lot of checks and balances with this and making sure that we're doing the right thing for our 8,500 members. and we're just trying to do the right thing. So, and have a lot of feedback and input, which has been great, a lot of review. So I appreciate you two immensely. Do you have any parting words?
Vote.
Advice? Vote. I like it.
Vote and understand the tremendous amount of work that Marcie and frankly the board did, that
Mhm.
all of our membership, the past presidents. I mean, this was a large effort from a large number of people, and so I hope we don't have to do it again. We'll take a look at it, but I hope we don't have to do it again for at least 2 years.
Well, not
So,
not a
thank you.
huge overhaul, whatever. So you're going to be
Yeah.
getting, our membership will be getting a ballot. You get an electronic ballot. It's the first time we've used electronic voting, and it's pretty streamlined. It's tied to your membership number. We have no idea how you voted. We won't know how many votes we receive or we'll know that, but we won't know, what the balance is of voting up or voting down until the actual number is provided at our special business meeting, which is July 18th, starting at 8:30. We have networking between 8:30 and 9, and we will announce, we'll close the voting at 9:45 a.m. that morning. And then following that, actually, it's great. We're going to have an update on the NAR settlement with Joanna Watkins from Florida Realtors and hopefully a spokesperson from NAR. I'm trying to get President Kevin Sears to give us an update. So, or Katie Johnson, their chief legal counsel. So they kind of work back to back, and this is a huge undertaking. So thank you very much. And like we said, please vote. You only get to vote once. So take some time, review the summary sheet that we're going to attach here. But for that is it. Wasn't a podcast fun?
It was.
Super fun. Yeah. There you go.
Well, thank you both. And thanks
All right.
everybody.
Thank you. All
Okay,
right.
bye.
Take care.